Hello, my name is Terry Gage-Klein and I'm a solicitor at Russell-Cooke in the Personal Injury and Clinical Negligence Department. In this video, I am going to be discussing the time limits that apply to bringing claims for catastrophic injuries and clinical negligence. This is known as the limitation period. Limitation in clinical negligence and catastrophic injury cases is a crucial deadline. It is the date by which the claim needs to be issued at court to stop the claim from being out of time. Limitation is always fact-dependent and is one of the first things that your lawyer would try to pinpoint. The starting point for limitation in most cases is 3 years from the date of incident. This is particularly true with, for example, a catastrophic road collision, where it will be clear from that day that the injuries are significant and have been caused by the incident. Unless there are other considerations, the limitation will be the 3-year anniversary of that collision. I'm going to go through some exceptions. Limitation based on date of knowledge is particularly relevant in the context of clinical negligence claims, where it is often only some time after the negligent treatment that a patient comes to know that they have been harmed. The law allows claimants to bring a claim as long as it is within 3 years of the date of knowledge of the negligence. This is couched in terms of when the claimant knew or ought to have known that the injury was attributable to the negligence of another. Examples in my practice have included delayed diagnosis of cancer, where the date of knowledge will be the eventual diagnosis of cancer rather than the date it was missed. Also, when substandard surgery only comes to light when highlighted by a surgeon carrying out further surgery in the same area, potentially years later. In claims for children, the limitation will not start to run until the child reaches 18 and will then be 3 years, so until they are 21 years old. This does not mean that claims cannot be brought for children earlier, and that is often the right thing to do, in which case it's done through an adult litigation friend, bearing in mind always that any settlement for children must be approved by the court. Sometimes a claim is running for a person with lawyers instructed and a limitation date calculated, and the client then sadly dies during the process. This resets the limitation period, and it is 3 years from the death. Sometimes the claim is arisen purely because of someone's death, whether as a bereavement as a result of a catastrophic incident or clinical negligence, and the claim is for their death. In those circumstances, the limitation is again 3 years from the date of death. Where someone is injured by a criminal act, a claim can be made to the Criminal Injuries Compensation Authority, the CICA or CICA. As this is a scheme separate to the civil courts, the CICA have their own rules, which includes a 2-year limitation period. However, there are certain circumstances in which the 2-year time limit can be waived. According to the CICA themselves, the most common circumstances of the time limit being waived is in relation to claims involving sexual assault or abuse. This has certainly been the experience for our team in terms of historic sexual abuse cases. Compensation can be sought for breaches of the Human Rights Act, which enshrines rights granted by the European Convention of Human Rights, such as Article 2, Right to Life, Article 3, Freedom from Inhumane and Degrading Treatment. When such breaches are actionable, there is only a 1-year time limit. It is something to be keenly aware of. If someone lacks mental capacity, there is no time limit for bringing a claim. This can be particularly relevant to brain injury cases. However, each case will turn on its own facts and a capacity assessment may be required. Further, there is the added complexity of fluctuating capacity. If a client were to regain mental capacity, the 3-year time limit will start to run from the date they regain mental capacity and run against them cumulatively for any time they have that requisite capacity. In a global world, there are accidents abroad, as well as negligent surgery abroad, particularly in the context of elective cosmetic or dental surgery. Provided it is appropriate to bring the claim in the UK, this can be done, but it is likely that the law of the country where the incident occurs would apply. That country may have different laws relating to limitation, which would have to be applied. Now that I've outlined some possible limitation deadlines, the next question is what to do. Well, it's important to know that commencing communication with the defendant, such as a complaint letter or even an intimation that you are going to bring a claim, is not enough to stop limitation from running. In fact, a claim form has to be issued at court, which means completing a specific court form with the full and correct details of who the claim is made against, as well as brief details of the claim and a court fee, this then being delivered to the court and sealed. This starts a timetable for a number of other steps which must be complied with. It is possible for defendants to agree extensions to limitation, but they may not always be inclined to do so. At present, there is a COVID-19 protocol which allows claimants, in claims against NHS hospitals and some claims against GPs, to extend limitation without consent. However, how long this protocol will continue is yet to be seen. Also, the protocol is limited as it does not apply to private hospitals, private doctors, dentists or historic GP cases. There is also no protocol for claims in the sphere of road traffic collisions or employers' liability claims. So, if you think you may be anywhere near a limitation date, it is worth seeking legal advice. Even if limitation is some time off, it is always better to approach a lawyer in plenty of time, as the necessary investigations to establish whether there is a viable claim can take some time.